Vitro, the Mexican-based glass manufacturer, defaulted on $1.5 billion of debt in 2009 after a crash in demand from the US market. Vitro is now facing legal chaos with a bankruptcy plan which has preliminary approval in Mexico but is unenforceable in the US. Here to discuss the case and cross-border cooperation between the US and Mexico is Dario Oscos of the law firm Oscos Abogados. What's the background behind the case?
Well, in 2009, Vitro executed with its subsidiaries a finance and corporate restructuring by means of which Vitro increased its participation in the capital of the subsidiaries, and the subsidiaries increased significantly the account receivable against the Vitro Sub as a holding company. Thereafter, Vitro Sub filed in Mexico what we call concurso mercantil. Concurso mercantil is an insolvency proceeding very similar to the Chapter 11 in the United States with debtor in possession. The main purpose of this insolvency proceeding is for the debtor and creditors to seek a reorganization plan to settle the debt and to overcome the distressed financial situation. So Vitro Sub filed first in Mexico, and the district court at the time rejected the intercompany debt and rejected the concurso mercantil. Then Vitro Sub appealed, and the Court of Appeals in Mexico, in the city of Monterrey, reversed the rejection, acknowledged the intercompany debt, and adjudicated Vitro in concurso mercantil.
Vitro's request to enforce Chapter 15 was rejected by the court in Dallas. What is Chapter 15 and what's the significance of this ruling?
Chapter 15 refers to the ancestral model law on cross-border insolvency. The purpose of this model law is to harmonize the different jurisdictions worldwide as to insolvency proceedings in the different countries. So in this case, Vitro sought that the Mexican reorganization plan be recognized in the United States and be enforced in the United States. But the Dallas court found that the reorganization plan manifestly violates U.S. public policy. Why? Because it cuts the debt of the subsidiaries of Vitro, which had not been yet adjudicated in bankruptcy whatsoever on one hand. And by recognizing this reorganization plan, it will imply also that the plan has to be obeyed by third parties, such as the intercompanies, subsidiaries that are not in insolvency proceeding.
So why is this case significant in terms of cross-border cooperation in business between Mexico and the US?
Because it may provide, eventually, when this case be overcome, the limits as to how a foreign reorganization plan may be recognized in the United States. And that will give guidelines for everyone in the world, considering that both legislations adopted the ancestral model law on cross-border insolvency.
So what's the role of Oscos Abogados in this case?
We have been representing some of the bondholders, the indentured trustee, and we have been in all levels of this proceeding, even in the Court of Appeals, in which right now the Court of Appeals in Mexico will review the Vitro's inclusion of the intercompany debt and the voting of the subsidiaries as voting creditors to approve the reorganization plan.
So finally, how do you see the case unfolding over the next year, and how long until we reach a conclusion, do you think?
Well, in the United States, the decisions from the Court of Appeals, which will review the rejection of the reorganization plan, may take at least 1 or 2 months. And I understand that that will be final decision that will become res judicata decision. In the case of Mexico, the Court of Appeals will review these issues, but whatever decision is made by the Court of Appeals, it allows 2 further appeals. In Mexico, the case may take from 6 months to 1 year to be decided finally.
Dario, thank you very much.
You are very welcome. Thank you.